the record. This is a request for an appeal of an administrative decision pursuant to section 151-3.15 of the 2011 Clay County Land Development Code pertaining to a written interpretation given on March 22nd, 2017 regarding whether or not church or religious assembly, as used in the code, allows for a church to manifest in any residential option, whether that be clergy/staff housing, convent, monastery, homeless shelter, battered women's shelter, guest housing, retreat center, or any other traditional and common way that a church might feel led by their faith to manifest their church. The applicant is Doug Perry, the Church of Liberty, representing Mill & Company, LLC. This property is located at 14518 Old Quarry Road and is approximately 67 acres. A portion of the property is zoned C3, which is commercial zoning, and a portion of the property is zoned agricultural. The appellant has requested an appeal of the manager's administrative decision, and the planning and zoning manager's written response for March 22nd, 2017 is as follows. A residential use is not included in the accessory uses of a religious assembly, mega, or religious assembly standard. The appellant's request you can see on the front page of your staff report as well as the second page. The applicant has supplied some additional material that was part of your staff report. And I would be happy to answer any questions that the board may have.
Any questions on the board? Well, I'm sure there's lots of public comment.
Yeah, and the applicant is here, and I do not believe Mr. Perry was sworn in, so we need to swear Mr. Perry in. If
you come forward, we'll swear you in. Anyone who wishes to speak. You solemnly, raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I so affirm.
Would you like to make some comment on this?
Yes, sir. Thank you. Ladies and gentlemen, I come with two issues. One is the way that the code is being interpreted, and the other is the way that the code is written. Churches have a unique position in constitutional law in this country, and the government has to show that it has a strong burden before it can manipulate or control or legislate the manifestation of a church. My first issue is with the way the code is interpreted. If I can refer to the exact definition, it's in the letter that I included for you, I believe. No, it's not. Let me get to page 200 and something of the code here. It defines religious assembly as a use located in a permanent or temporary building and providing regular organized religious worship and religious education incidental thereto, but excluding private, primary, or secondary educational facilities, community recreational facilities, daycare facilities, parking facilities. Property tax exemption obtained pursuant to state law shall constitute prima facie evidence of religious assembly, which of course we have. And then religious assembly mega, it says a place of religious assembly that contains parking for more than 300 cars or sanctuary seating for more than 400 persons, and may also have accessory uses such as gymnasiums, school classes during the week, daycare, etc. And then it defines religious assembly standard as a place of religious assembly that contains parking for less than 300 cars or sanctuary seating for less than 450 persons, classrooms, and a fellowship hall. Now, that is a very typical, very American definition of a typical Christian church. Dividing them between mega and standard is not a problem. You can decide what size parking lot goes with which. The problem is that the code is being interpreted as, even though it says such as, or it says etc., those are the only things that a church can do. If I ask Kip, can we have a retreat center? He says, no, that's not on there. Even though retreat center is in the definitions on the next page, as a facility used for professional, educational, or religious conclaves, meetings, conferences, or seminars, which may provide meals, housing, and recreation for participants during the period of the retreat or program only. Such centers may not be utilized by the general public for meals or overnight accommodations. Retreat center is never repeated in the code anywhere. We've done a word search. Kip confirmed that the word retreat doesn't exist in the code anywhere. So how does a church have a retreat center when it assumes churches can have retreat centers, when there's no residential option for churches, and yet retreat center is listed in the code as if it ought to go somewhere, and yet there's no link to it anywhere? So I went through about a month ago. We are currently doing animal production. The goal for the farm has always been to be an intentional community, to live out our faith in community, as 1,500 Christian communities all over the United States do, and have throughout history. To be a teaching farm, to teach sustainability, to be a place where people can come and learn how to raise rabbits, how to raise goats, all the different things we do. We currently have rabbits, quail, goats, sheep, pigs, geese, chickens, and other things on the land. Under animal production, which we're zoned for in C3, about a month ago or 2 months ago now, Kip called and said, you're raising rabbits. That's not listed under animal production. Rabbits are listed under domestic, not farm animals. Where animal production says...
Chairman, does this have any reference to the question that was asked?
It does, because my point is that the code is being read as a list of the only things you can do, even when it says such as or etc. It's being read as the only things. Because rabbits were on the list of farm animals, I had to go to talk to Missouri State Conservation. I had to get documents from Missouri showing that they're traded at the livestock auctions, that they're under livestock as far as Missouri is concerned. If we had one rabbit and called it fluffy, that's one thing. We have 200 rabbits and we sell them to people to eat, and we eat them on the farm. That's livestock. But I'm just using that as an example of how the code is being read as the only thing churches can do. If I ask Kip, can I have a bus ministry for the church? He says, well, you have to be zoned for commercial parking lot to park the bus. If I say, can we have a puppet show? Well, you got to be zoned for outdoor entertainment or indoor entertainment to have a puppet show. No, those are the things churches do. And if we were a Buddhist monastery or a convent or a Sikh, Muslim, all kinds of other groups where people live on site with the temple, with the church, this description doesn't apply to us at all. There's no pathway to be a church and to have a residential option, even though retreat centers are listed in there. So one problem I have is that the code, when it says such as, should not be the entirety of the list of what a church can and can't do. Churches are in a very unique position as far as law, and you have to show why, in a C3 zoning where we are, we can have hotel, we can have, let's see, I got a list here. We can have congregate living, which is essentially a homeless shelter, which we said we didn't want to be, but we're permitted by right and could have been all along. Group homes with a conditional use permit. Convalescent center, permitted by right. Hospital with a conditional use permit. We could be a hotel motel. We could have accessory apartments and accessory dwellings. Those are all residential options that are allowed in C3. If we can have a hotel, you have to show why you have an overwhelming burden to deny us being a church that is residential, that has people staying on site, that has a retreat center. And I reference our LUPA, which is the Religious Land Use and Institutionalized Persons Act. And the code, the federal code for our LUPA, that talks about that this is the law of the land, that constitutionally the courts have decided that churches, especially new and unusual churches, that might face persecution or prejudice, need to be handled very carefully in terms of zoning. There's also the Religious Freedom Restoration Act for Missouri that essentially says the same thing. So you are the Board of Zoning Adjustment, and I'm suggesting that there needs to be some adjustment to the zoning, because what is just a description that somebody wrote, hey, this is kind of what a church looks like, has ended up being the only things a church can do. And that's not constitutionally okay. That is a violation of the Establishment Clause. We've been 2 years on the property, trying to fit in the cracks here and there and find what we can do. We had a zoning application, but we were treated as a big developer. And that's not the point at all. The point is that we're a church that wants to live out its faith by living on the property. We're not trying to get around zoning, building codes, or anything else. The whole question is, do you have the authority to tell a church that they can't manifest church residentially? And I don't dispute that Kip is reading what the code says, but Kip is reading what the code says as a list of the only things churches can do. And if you meant to write the code that way, you should have allowed for a whole lot of other things in there that churches do, just as a normal basis of stuff. I've given you in the letter, one after the other. St. Anne's has people living there in Excelsior. St. John's has priests living there. Others that have homeless shelters, others that have battered women shelters, and they're all just zone church. They don't have to go and get some big neighborhood zoning or multifamily, whatever. Those are some of the things that churches do. And when I present that, the argument is, well, not in rural Clay County. In Liberty they do, in Excelsior they do, and in other places they do. Providence Baptist Church has a parsonage, but that was grandfathered in. So every example that I say, look, what about this, what about this? Well, that's not here. Well, that's because they know they're not supposed to live in churches that way and restrict so tightly the manifestation of our faith as a group. And I'll be glad to answer any questions you might have.
Any questions from the board? Well, at this time, I'd like to entertain some opposition. Anyone want to speak for opposition?
And Chairman,
Mr. Perry.
Chairman, I think we would just want to open it up for public comment, whether it's in opposition or in favor of.
Yeah.
I just want to make sure that's clear, that it's opposition or in favor of.
That's right about that. Any other comment?
Hello.
Can you state your name?
I've already been sworn in, but my name is Elena Niemeyer. I'm located at, excuse me, 14621 Old Quarry Road. I reside in the only house directly across from the cave area where Mr. Perry is speaking. For the record, I would like it known that our attorney John Rowe is still representing David and Shannon Colvin, Richard and Shauna Johnson, Jim and Gail Colvin, Rob and Pat Wysong, JT and Carol Stockwell, and myself, Elena Niemeyer. Mr. Rowe was unable to be with us this evening due to a scheduling conflict. However, he felt, after reviewing the appeal, that Mr. Perry appealed, that he felt that Mr. Jones' official decision is still correct. Mr. Jones does not have to prove that he is right. The burden is on Mr. Perry to prove to you that Mr. Jones was wrong. And once again, he's failed in that burden. The administrative official, Kip Jones, did not make an error. The interpretations were correct. Mr. Perry's attempt to once again obtain zoning and zoning approval by intimidation is inappropriate. He continues to stand in front of you, asking you to tell him that you should be the one to determine what is wrong. The intimidation tactic is not correct, and we would urge each one of you to not succumb to that intimidation technique because it is not appropriate. What is appropriate here is that the interpretation of the entity charged with interpreting this code, and they have already reached the right conclusion. Mr. Perry wants to talk about religion and religious acts. We would like to point out that when you look at the religious acts, it is very clear that the act is not a blanket exemption from zoning laws. As a general matter, religious institutions must apply for the same permits and follow the same requirements and go through the same land use processes as all other land users have. The act does not preempt or replace the normal zoning code, but that's what the applicant is trying to get you this evening to do. He is attempting to threaten the county by citing various legal actions, trying to preempt or allow him to do something that is not allowed by your code. This is simply required, he is simply required to follow the same codes and ordinances that everyone in Clay County has been asked to follow, church or not. Today's pretty simple. You have a request for an interpretation by an applicant. You've got a written decision on that by the staff. You have an appeal to you by the appealant, and your code says that you have to presume that Mr. Jones was correct, and you have to place the burden of persuasion on the applicant to show an error has been made. He did not. Instead, what he did was talk to you about having him tell you why you're doing what you're doing, and that is not how this whole process is supposed to come about. He mentioned earlier about, I have here the presumption that Mr. Jones told you is correct. The mandatory, that you start presumption, the word shall is a mandatory word. How do we know that? Because your code tells us that in section 151-1.10. The words shall and will, must and may are mandatory. He makes mentions of St. Anne's, which is inside the city limits. St. Anne's has one home on that ground for the priest. This is not comparing, because he is asking to have several people live there. Not an entire congregation is at St. Anne's Catholic Church in Excelsior Springs. So because he's failed in his burden, you are obligated to affirm the decision, and we ask you respectfully to affirm the decision made by Mr. Jones and deny this appeal once again this year. Thank you.
Thank you. Any other comment?
Robert Lysong, 1216 Ann Avenue. I don't know how many churches are in Clay County. I'm pretty sure they all met the zoning laws of the county. And he said it himself, Mr. Perry, he wants an intentional community. That's what he's going for. He's trying to skirt the zoning laws. Thank you.
Thank you.
Molly McGovern, City Manager of Excelsior Springs. I just have one question, really. There's been no comment about the need or requirement for sewer to support residential uses on the property. I really thought that that's partially what this conversation was about. I think residential uses require sanitary, safe housing, and that is in compliance with development code for the county, as well as DNR, EPA, county health codes. Isn't that really what we're about, as opposed to redirecting what is included and what churches can and cannot be about.
And I can answer that question if you'd like me to, Chairman. Tonight is about the interpretation of the code. Clay County does not have a application for any kind of development at this point. If we would obviously look at that at that point. Yes, ma'am.
Any other comments? I know we swore in several people. Anyone else want to talk? Mr. Perry, if you want to come back up, you can.
It is not my intention to intimidate anybody. My hope is to come before you guys where somebody will have some common sense and see that that definition of church doesn't apply to all churches. And there are all kinds of groups from all kinds of religions that might want to come to Clay County, and that definition doesn't apply to them at all. An intentional community is a church if it's a church-based intentional community. That's what the Book of Acts started as. That's what we feel like we are. There's always been groups through history like the Shakers, the Quakers, the Hutterites, even the Amish and Mennonites that have lived in community. Here they have their own farms or whatever, but a lot of times through history they've lived in community. There are a lot of reasons to do that. That is an important part of what we believe and what we have been living for the last dozen or so years. This intimidation that's being referred to is simply the reality that if you all, as a group, don't adjust the code, then we have to appeal to Clay County Court. That's the next step in the appeal process. The next step after that is to go to federal court as a human rights violation and a violation of the ARLUPA federal law. It just is. I'm not trying to threaten. I would rather it just be settled now than be settled later with lawyer fees and other costs to the parties involved. I believe that I have shown that the code is being interpreted as a list of the only things you can do instead of a general description of what a church might look like. If you want to divide mega and standard by how many cars are parked there, that's fine. But if you're going to make a list of the things churches can and can't do, this isn't it. This is not anywhere near complete. And for example, I mentioned retreat center is nowhere to be found, even though it's in the descriptions. So something's wrong with the code, and I'm hoping the Board of Zoning Adjustment can adjust it for it to make some sense. Churches are in a unique position, and I expect that other churches need to abide by whatever Clay County zoning says. But there's all kinds of churches coming that may not fit the normal pattern of church that you've defined for them, and that's a constitutional problem. A church doesn't have to abide by the same zoning rules as a farm or a residential house or whatever. Churches are constitutionally different. This may not be the place to argue a constitutional issue, but I'm hoping you'll look at the definition of church and look at your own church where you go and see if there aren't things you're doing that aren't inside that code that would be in violation of the Clay County Code. Anyway, thank you. Appreciate your consideration.
Thank you for your comment. At this time, this is one variance.
You have three choices. So one isn't a variance. It is a.
Oh, would you like to come up and say something else?
I would like to just add that Mr. Perry is correct in what he just got up here and said, and it's very possible that other unique churches and groups are going to want to come to this area, and your vote tonight will set precedence in that. And I would think you would want to consider that while you're voting. Thank you.
Chairman, I might add one more thing that maybe should have been part of the staff report. Is part of Mr. Perry's question that I made the response to. Several of those items are listed in the land development code, such as homeless shelter is in transitional housing. So that is a use that could happen on that property, but it'd be a conditional use permit. Congregate living is mentioned in group homes. And there are accessory apartments, guest houses, and dwelling units that can be used possibly on that property if the property owner would go through a conditional use permit, which goes through the Planning and Zoning Commission and County Commission. So there are some residential uses or some of the things that were mentioned in the request that are possible for that property. So I just wanted the board to know that as well.
Yes, just a point of clarification from Mr. Perry. Okay. If I remember correctly, you said that churches are not subject to zoning rules?
Mr. Perry, can you come up to the microphone, please?
No, churches are absolutely subject to zoning rules. But zoning has often been used as a club to restrict religious movements in one sort or another, either because they don't want them in a strip mall because they don't want the tax revenue, or because they don't want that group in the town at all. I'm concerned about Ms. Niemeyer's comment that you're setting a precedent that some of those groups might want to move to Clay County, and we might have a Buddhist temple I'm not sure how to feel about that comment, that you should restrict churches so that weird ones won't come to Clay County. Anyway, yes, we have to abide by building codes. Yes, we have to be connected to sewer or DNR, or all of those things are part of the presentation for what's going to be built there. The thing is, nobody, a church doesn't have the same zoning restrictions as a house or a farm or something else. The code goes through. Here's what apartment complexes have to deal with. Here's what farms have to deal with. Churches have their own unique section in the code of how zoning applies to them. Okay, so a residential home like Ms. Niemeyer's is not restricted by whether they can have a gymnasium or a fellowship hall or whatever. They have their own set of setbacks and all of those kind of things. My point is that the section of the code that relates to churches is fundamentally broken, is too limited, and doesn't allow for the free expression of religion. And that is a constitutional problem, because churches do have to be handled carefully constitutionally. The courts have repeated, that's the whole point of our LUPA. I've got the text of our LUPA in there in a summary of what it says. But the highest court of the land and the Congress has said that the government needs to show why you are burdening a religion by restricting them. And despite Mr. Rowe and his comments that he's, of course, paid to argue, that is the law. That is what our LUPA says. That is what a court will say. And I'm hoping you can see that before we have to go through all of that.
Any other comments of the board members? Any other comments from the public? The board, sir.
Were you part of the initial swearing? Okay. And then he'll need to be sworn in.
Sure. Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir. Brad Eels, Mayor of Excelsior Springs. Just have one, because I'm not going to address the whole issue with infrastructure and everything else, sewers, waters that we've been through again and again. This is a question of amending the code. When somebody comes to me and our code is to amend the code, we request that we have a planned development to show what that code is going to cover. We don't just change a code to fit a blanket policy across the world to try to make it fit for whatever we want to do. The only thing I'm asking is, you reference that we have no plan for this property, and you don't amend codes before you address what's going to be there. That would be like asking for rezoning of a property for whatever I want to do, from residential to commercial, or commercial for residential, or multifamily uses, without knowing the planned development before you amend it. And then next week I come back to you and ask you for it to be rezoned or another ordinance to be changed to fit my project because I've changed my mind on the project. You have no planned development on your table. Thank you, sir.
Any other comment? Anything to say?
That's it for staff.
I'll clarify to the commission what your role is in this, because it's a little bit different from some of the other things we've done. The code's clear that Kip's decision is given a presumption of correctness. The appellant has the burden to show that it was incorrect. And also under the code, the appeal is only sustained if you determine that the administrative actions or the administrative official erred. So you sustain the appeal if you believe that he erred. You deny the appeal if you do not believe that he erred. That's the only question. There's not really a question of changing codes or finding any constitutional findings tonight. Was his interpretation of the code correct or was it incorrect?
So I think we're ready to entertain a motion. Do I have a second?
Can we hang on a second? Is that the correct wording to say?
That will go through legal counsel, so you want it,
You can say, if you want to, whoever made the motion, they can amend it to say that you reject the decision, you affirm the decision, or you modify the decision. So if you want to deny the appeal, then what you'd be saying is that you want to affirm the manager's decision as to the written interpretation.
so Mr. Whitney's restate.
There's suggested bringing page 2 for the 3 options that you guys have to make. At the bottom there, there's your 3 choices.
So just to restate, if you say affirm, then you are agreeing with the manager's decision. If you say reject, you are disagreeing with the manager's decision.
And then the third option is to modify and come up with your own decision.
Change my motion to affirm the manager's administrative decision.
Second. This time we have a motion and a second. I think it's time to have a vote.
Randall Morris. Approved. Larry Whitten. Christie Saligo Fleshman. Zachary Kramer. Approved. Chairman Buddy Roush.
Affirm. Conclusion.
I have one thing for the board members, since we do have an application for next month. So we will have at least one case, possibly 2 for next month, so please plan on attending.